Thank you, and good afternoon, everyone. My name is Michael Kimberly. I'm a partner here in Mayor Brown's Washington, D.C. office, and I'm a member of the firm's Supreme Court and Appellate practice. Joining me today as a co-presenter is Associate Matt Waring. Matt is an associate also in our D.C. office and, along with me, practices in our Supreme Court and Appellate group. Before we begin, I have a couple of housekeeping announcements. First, as we go along, we hope that you will ask questions by using the Q&A panel on the right side of your screen. We will make every effort as we go along to answer your questions. If we're unable at any point during the webinar to answer your questions, we'll follow up with you directly after the webinar has closed. Second, regarding CLE credit, we will be providing an alphanumeric code at some point during the presentation. In order to receive your CLE credit, you must record this code in the virtual sign-in sheet that was emailed to you with the login instructions for today's program. And finally, I have one caveat. The typical caveat that the views here are Matt's and mine, and they should not be attributed to either Mayor Brown or Mayor Brown's clients. And with that, we will get started. So what really is this case all about? Some of this will be familiar to some of you and less so to others. The Clean Water Act, with limited exceptions, prohibits the discharge of any pollutant without a permit. And a discharge of a pollutant is the addition of a pollutant to navigable waters from any point source. Navigable waters really is the key term there, and that is defined somewhat unhelpfully as the waters of the United States, including the territorial seas. Now, the definition and meaning of navigable waters, and more specifically the waters of the United States, is a topic of substantial litigation and substantial disagreement, often between EPA and the Corps on the one hand and regulated entities on the other. That's especially so in the context of a new regulation that some of you will have heard about, called the WOTUS rule, or the Clean Water Rule, which is EPA and the Corps' efforts to define waters of the United States by regulation that has led to widespread legal challenges that remain ongoing. Now, a water or land feature deemed to be a water of the United States, the upshot of such a determination is that the land or water feature falls within the regulatory jurisdiction of the agencies as a result. And so the determination of whether a land or water feature is a water of the United States is understood to be a jurisdictional determination. This isn't jurisdictional in the Article 3 sense, it's jurisdiction in the regulatory sense. And so here, and we'll get a little more into the specifics of the question presented a little bit later in the presentation, but the issue in the Hawks case is whether a jurisdictional determination, a standalone determination by the Corps of Engineers that a particular land or water feature is or is not a water of the United States, is a final agency action that is reviewable under the APA. That question, which again is something we'll get into in a little bit detail, but is helpful in terms of framing the rest of our sort of the early slides in our presentation. It's helpful to know that an agency decision is reviewable under Section 704 of the APA if it is a, quote, final agency action for which there is no other adequate remedy in a court. Now, the reach of the Clean Water Act is, as Justice Alito put it in Sackett against EPA, notoriously unclear. Any piece of wetland, according to Justice Alito, that is wet or at least part of the year is in danger of being classified as a wetlands covered by the Act. And just to put that statement in some context, below is a very short outline, highly condensed outline of what the Waters of the United States rule issued by EPA and the Corps of Engineers in 2015 requires, and you can see it's a tremendously complex formula that requires agencies and regulated parties to consider not only the nature of their own lands and the water features on those lands, but also the interaction of those water features and their lands with navigable waters potentially hundreds of miles away. And that gets caught up in tests including, for instance, adjacency, which is not what you might expect from the plain meaning of the word adjacency. To determine whether something is adjacent is itself a very complex and functional test, and it also follows from what EPA and the Corps of Engineers have called their substantial nexus test, which calls for wide-ranging considerations of interactions between different water bodies in very subtle ways and with respect to often functions of water bodies that are somewhat unintuitive. And so to put it in a nutshell, the question, what are the waters of the United States, is a tremendously complicated and difficult question to answer. In order to discharge, whether under the MPDES program, under Section 402 of the Clean Water Act, or Section 404, the dredge and fill section of the Act, you have to get a permit. Permits are extremely burdensome and costly to obtain. This information that we're quoting here is taken from sources that were cited in the Rapanos case, suggesting that an individual permit, which I understand is at issue in the Hawks case, often takes, and indeed on average takes, more than 2 years and nearly $300,000, and that obtaining coverage under a general permit, which is a much less burdensome process, nevertheless still takes 313 days and tens of thousands of dollars to obtain. So this is a very, the permitting process under the Clean Water Act is a very complex, difficult, and burdensome process. It begins with the Corps' sort of a standard form that the Corps has called Form 4345. You've got to fill it out. It is also, in advance of actually filing an application, typical to meet with the Corps, and the filing of the application is indeed somewhat of a later step after initial analyses and discussions are already had. In response to applications for permits, there's additional back and forth between the Corps and regulated entities. There's a notice and comment period, and the Corps then issues its decision based on discretionary considerations. There are, as we'll talk about a little bit later on, intermediate steps here and also the possibility for appeals. These intermediate steps having to do with the crux of this case, which is jurisdictional determinations.
So given how lengthy and costly the Clean Water Act permitting process can be, it's understandable that landowners and other regulated entities would like to know as soon as possible whether their land might be subject to jurisdiction under the Clean Water Act in the first place, so that they know whether they need to go through this process. And so jurisdictional determinations are a mechanism that the Corps of Engineers has set up to help provide guidance to landowners on this question. So let's talk a little bit about what a jurisdictional determination is. The regulations authorize the Corps to issue these determinations, and a jurisdictional determination is a written document stating whether or not the waters of the United States are present on a particular parcel of land, and if so, where, and presuming that waters of the United States are present, whether subject to the jurisdiction of the Clean Water Act. They don't go to whether a particular activity by a landowner would require a permit, but just whether the act is potentially in play. And these jurisdictional determinations come in two flavors, if you will. There are preliminary jurisdictional determinations and approved jurisdictional determinations. A preliminary jurisdictional determination is similar to an opinion letter that an entity might get from another agency. They're informal, they're non-binding, simply meant to be advisory and state in general terms whether or not a piece of land contains waters of the United States. By contrast, an approved jurisdictional determination, which is the kind of jurisdictional determination at issue in this case, is a more formal process. The landowner will submit more information. The Corps will make a formal decision on the record, and that is binding on the Corps and the federal government for a period of 5 years. And crucially, an approved jurisdictional determination is subject to a further administrative appeal. That's not available for a preliminary determination, but an approved jurisdictional determination can be appealed through the Corps' internal processes. So there's a bit of review within the agency. And with all of that as regulatory background, it's also important to situate the case that was considered by the Court today in the context of the Court's previous decisions interpreting the Clean Water Act, because what these decisions illustrate is that the question of what are waters of the United States and what are the boundaries of the Corps' and EPA's jurisdiction under the Clean Water Act has been a hotly contested issue, and the federal government has continually taken a very broad view of the scope of its jurisdiction under the Act, and certainly a perfect illustration of that is the first case on our list here. That was the Swank case in 2000, which was handled by Mayor Brown, and Tim Bishop, who's a partner in our Chicago office, argued that case and won it. This was a case involving a consortium of municipal entities looking to construct a bale fill project in northern Illinois, and the question whether part of this project would cover waters of the United States was a critical one. And here the landowner ran into a rule that the Army Corps had promulgated called the migratory bird rule. And under that rule, even an isolated water not connected to any navigable waterway could be considered a water of the United States on the theory that it's a habitat for migratory birds and it's connected to the broader ecosystem. And thankfully, I think from our perspective, the Court rejected the Corps' construction there, saying it was simply too broad to be upheld under the statute, and also noting that if the statute really could be read that way, there would be constitutional concerns, because there would be a serious question whether Congress's power would even extend to these ponds of water in the middle of nowhere that are simply used by migratory birds. So the way the Court articulated the necessary the test for Clean Water Act jurisdiction in that case had to do with whether a body of water had a significant nexus to a traditional navigable waterway. And shortly after that, these issues came up again in the Rapanos case in 2006. And there the court was looking at whether wetlands and other waters sort of connected by ditches or culverts that sort of drained to navigable waterways could be considered waters of the United States. And this case as you would expect given the vagueness of the definition of waters of the United States, actually produced no majority opinion. Instead, we got 3 different opinions, each taking a different approach. The 4 conservative justices at that time, Justice Kennedy, Justice Scalia, Justice Thomas, and the Chief Justice would have held that to be a water of the United States, a body of water has to be relatively permanent, and that it has to be continuously connected on the surface to a navigable waterway. And the 4 liberal justices would have agreed with the Corps' interpretation that any water can be a water of the United States as long as it's sort of geographically adjacent to a navigable waterway, whether it's connected or not. And Justice Kennedy took something of a middle position, trying to stick with the significant nexus formulation from the Swank case. So these are issues that have been, there's been a back and forth between the court and the agencies on this subject for quite a while.
And, you know, just to add very briefly, I think what I would say is particularly pertinent about these cases for present purposes is that they are 2 examples of cases that ultimately turned on a single question, whether the land and water at issue was in fact a water of the United States within the meaning of the statute. In other words, those cases, each after decades of litigation and millions of dollars spent, turned on this threshold question of whether the determination that the agencies had jurisdiction under the Act was a correct one. And so these cases, in addition to providing this sort of substantive background, help also color the practical considerations that are at issue in Hawks. Now that brings us to the facts of Hawks.
Yes, this case arises out of the 8th Circuit, and it involves a piece of property in Minnesota, and this is a piece of property that the Hawks Company had an option to buy and use for peat harvesting. And they didn't anticipate this would be a problem, given that the property is located about 120 river miles from the closest navigable waterway, which is the Red River of the North. Nonetheless, they submitted an individual permit application for the development that they were going to need to do to the Army Corps of Engineers, and as one of the initial stages in this permitting process, the Corps issued a preliminary jurisdictional determination, and that jurisdictional determination indicated that there were some wetlands on the property that were going to be covered by the Clean Water Act. And the company decided to contest that determination, so it asked the Corps to formalize this position in an approved jurisdictional determination. And unsurprisingly, the approved jurisdictional determination reached the same conclusion as the preliminary one, finding that there was a significant nexus between the wetlands on this property and the Red River, despite the great geographic distance between the two, and thus that a portion of this property was within the jurisdiction of the Clean Water Act. The company exercised its right to the administrative appeal and won that appeal on the ground that the agency had not compiled an adequate record showing the necessary nexus. But on remand, the Corps reissued essentially the same determination, again, this time as a revised jurisdictional determination or a final jurisdictional determination, essentially again finding a significant nexus between a portion of this property and a navigable waterway, and thus finding waters in the United States on the property. And at that point, the Corps' regulations provide the company has no further recourse from the agency. And so that's when the company found itself in district court suing under the Administrative Procedures Act.
So as we talked about at the top of the presentation, the Administrative Procedures Act provides for review of agency action when the agency action is a final one for which there is no other adequate remedy in a court. Central to the question whether a jurisdictional determination or any other agency action is a final agency action is what's called the two-factor Bennett test. According to that test, the first question is whether the action is the consummation of the agency's decision-making process, and that factor is designed to weed out circumstances where there's an informal decision made internally that may not reflect the full consideration and deliberation of the agency. And the second question is whether presuming that it is, that the agency action is the consummation of a formal decision-making process, whether it affects private parties' rights and obligations, or whether legal consequences flow from the action. In this case, the government has all but admitted that and conceded that the first factor is satisfied here. The approved jurisdictional determination was the result of a long and expensive and complicated process and analysis, and on its face is the consummation of an agency's decision-making process. So the question in this case really turned on whether rights and obligations are followed from or affected by a jurisdictional determination, or whether other legal consequences flow from a jurisdictional determination. Now that brings us to the procedural history of the Hawks case. Hawks, after the agency issued its final jurisdictional determination, but before proceeding with a full permitting process, Hawks Company filed suit under the Administrative Procedures Act. The district court dismissed the case, finding that it was not a reviewable action within the meaning of Section 704, and the Eighth Circuit reversed, holding that it was immediately reviewable. As to the first prong, the court quickly decided that it was indeed the consummation of the court's decision-making process on the threshold issue of the agency's statutory authority to regulate the lands at issue. And turning to the second prong, the court found that a JD determines rights and obligations. It found little difference between an agency order that compels affirmative action, such as the EPA compliance order that was at issue in the Sackett case, which is a case, unfortunately, that we didn't have time to talk about earlier, but involved a EPA determination, an enforcement order requiring people in that case who were subject, in the EPA's view, subject to regulations under the Clean Water Act, to comply with the order. It was literally an order ordering them to do something. The Eighth Circuit likened a jurisdictional determination to a compliance order of that sort, because in the court's view, a jurisdictional determination in legal and practical effect prohibits a party from taking what would otherwise be lawful action. In this case, for example, harvesting peat from the land without a permit. And so the Eighth Circuit reversed. The Corps of Engineers filed a petition for certiorari, which was granted, and the question presented in the case, as we've been discussing, is whether a determination that property contains waters of the United States, which is to say a jurisdictional determination, whether that is a final agency action for which there is no other adequate remedy in a court.
So first we'll look at what the government argued before the Supreme Court, and as Michael noted earlier, one thing that the government is not arguing is the consummation prong of the Bennett test, that first prong. The government effectively concedes in its briefs that a jurisdictional determination is the consummation of the Corps' decision-making process. It will not be changing its mind any further once it issues an approved jurisdictional determination. So the arguments that the government makes instead focus really on the second prong of the Bennett test, which is whether these jurisdictional determinations give rise to legal consequences. And then relatedly, the other requirement of the APA, that the party seeking review have no other adequate remedy in a court. The government tries to show that, in fact, there are several other avenues of adequate remedy in a court, and we'll see what those are. But the first theme that the government that really stresses in its briefs is that jurisdictional determinations don't change the rights or obligations of a landowner. A landowner's rights and obligations are created by the Clean Water Act itself, and a jurisdictional determination simply informs the landowner of what the act itself is imposing on it. So while they provide more information for a landowner to make decisions, that the jurisdictional determinations don't themselves, they don't direct a landowner to take any action, they don't alter the potential penalties that it might face for violating the act, that they're simply essentially an advisory opinion. Another theme that the government stresses is that although jurisdictional determinations do certainly have consequences, which we've talked about, they may make landowners reticent to use the land, or they may alternatively make them feel compelled to seek a permit. Those are practical consequences. They're not legal consequences. And the government says that practical consequences aren't the sort of consequences that make an agency action reviewable under the APA. Another point that reappears again and again in the government's brief is the observation that nothing in the Clean Water Act requires the Corps to issue jurisdictional determinations at all. As originally enacted, the Act simply defines what the waters of the United States are and creates this permitting process. And the government says that if Congress didn't think that the agency needed to provide jurisdictional determinations at all, clearly it felt that landowners' other options besides obtaining review of a jurisdictional determination must be adequate to protect their rights. And so we see in this last bullet here that the government really argues that landowners should pursue one of these two alternatives. On one hand, if they feel, if they receive a jurisdictional determination saying that there are waters of the United States on their property and they disagree with that and they feel confident in their position, they can simply proceed with whatever they were going to do and simply raise the jurisdictional issue as a defense if and when they're sued by the agencies in an enforcement action. Alternatively, the government says they can apply for a Section 404 permit from the Corps, which the government says is the way that the Congress had in mind for jurisdictional issues to be resolved, that parties would go through the permitting process and get judicial review when and only when that process has been completed.
Now that leads us to respondents' arguments. Respondents' arguments are, at this point, and I hope should be pretty obvious. JDs are indeed the government's final word on jurisdiction. That conclusion follows from a few observations. The first is that jurisdictional determinations are binding on the agencies. Now, the government, for its part, takes a different view about whether jurisdictional determinations really do bind the agencies, whether the Corps, for instance, can revisit jurisdictional determinations, whether EPA can veto them or undertake its own analyses if it disagrees with the Corps' determinations. But setting aside those rather formalistic arguments, there is little question, at the very least, as a practical matter, that jurisdictional determinations are indeed the government's final word on jurisdiction. They are often undertaken as part of the permitting process itself as the first step, and regardless whether or not that is true, the agency is not going to revisit the question of whether the water or land feature in issue is a water of the United States. That determination having been made through the JD process, it will, for all practical purposes, bind the government. And that is so as a formal matter for 5 years. And you might, I think, a reasonable question to ask would be, well, what's the point of a 5-year sunset provision on a jurisdictional determination if it's not binding? Putting a sunset on something only makes sense in the context of a determination that indeed is binding. So that's their first critical point. The respondent's brief then focuses substantially on legal consequences, and it makes a few key points. The first is that it is that jurisdictional determinations are in form really a formal adjudication of jurisdiction, and of course adjudications of rights necessarily dictate what the rights of the parties that have an interest in the subject of the adjudication. They note also that jurisdictional determinations have a very real impact on liabilities. The Clean Water Act treats individuals and companies differently based on whether their violations of the Act, presuming violations are found, are merely negligent or knowing and reckless. And if a company like the Hawks Company has in hand a jurisdictional determination informing it that the areas that it wants to harvest for peat are protected wetlands, it's virtually impossible for Hawks to show in later litigation, should it come to it, that its violation was not knowing. And so as a practical matter, the issuance of a jurisdictional determination will effectively increase the civil and legal liabilities to which regulated entities are exposed. There is also a loss of a right to use the property. This is a recurring theme in the briefing and came up repeatedly at the oral argument today as well, which we'll talk about shortly. But the point is that a jurisdictional determination, in essence, can rob a land user or owner of the viable economic use of its land. Here, for instance, if the land is in fact, if the land does indeed include a jurisdictional wetland and the Hawks Company cannot harvest peat, the land of the Hawks Company becomes essentially valueless. There's little question in this case, we're told that the Corps would deny a permit application. But even if there were an open question about whether the Corps would grant an application, it's an open question whether the Hawks Company, which would have to seek an individual permit in this case, would have the financial wherewithal to do that. And that's so because although the company is in good shape now, as many sort of similar mining businesses operate, the question is whether there is sort of future stock that the company can continue to harvest. As we understand it, the Hawks Company has 2 other sites where it's harvesting peat. The useful life of those sites is coming to an end, and the Hawks Company needs to find a new area to harvest peat, and it can't wait 2 or 3 years before beginning harvesting this land. And if it doesn't begin harvesting this land, it will effectively, it may anyway, have to shut down its business. And so the loss of the right to use this property as a functional matter is a matter of enormous consequence that has wide-reaching legal consequences you know, it also has consequences for actually how the land is valued and how, you know, what sort of financing this company or other companies or other individuals might be able to get using the land as collateral. And all of this means, as Matt and I have been talking about, is effectively, particularly in light of the increased legal liability, which includes $37,500 per day per violation in fines and civil fines, and a threat of indeed, I think it's up to 6 years of jail time for an owing violation. What it means is that landowners really are forced into the permitting process. No matter how confident they are about the correctness or wrongness of the agency's jurisdictional determination, few rational business people will be willing to bet the farm, in some cases quite literally bet the farm, on the possibility that they might win a later challenge, either in an enforcement action or in a challenge to a compliance order from the agencies. Knowing, incidentally, all along that while this is going on, they're continuing to rack up liabilities. The brief then also discusses at length, and so just to put it very succinctly, the consequences here are either one, to abandon the project at great cost, to proceed with the permitting process at great cost and with no promise that the company will be able to do what it wants to do with the land, or take on bet the company liability in pushing forward with development or harvesting or mining or farming or whatever the case may be, and yet risking enormous liability. So the question then arises assuming that it is a final action, whether alternative avenues are inadequate or adequate. And the government argues that these other possibilities, including primarily waiting until an enforcement action or permit process, there's a compliance order and an enforcement action begins, in which case these issues can be litigated, or waiting for the permitting process to conclude, in which case an APA suit can be filed then, are adequate remedies. And respondents make very persuasive practical observations folding in on the earlier points they made about the various burdens of taking either of those approaches, including, again, going through the great cost, often simply impractical cost, of obtaining a permit, or risking liability and essentially asking for a compliance order that exposes the company to enormous liability. So it's noteworthy that in addition to the parties briefing, there were 16 amicus briefs filed supporting Hawks, the respondent in this case, and not zero briefs filed in support of the government. The 16 amicus briefs filed in support of the Hawks Company included 20 businesses and industry groups, 29 states, and 6 associations of state and local governments. So there was wide-ranging interest in the case, and nobody was interested in supporting the government's view that it ought to be able to issue these decisions without immediate review. One of the briefs filed, and this is the brief that Matt and I worked on along with Tim Bishop, was a brief filed on behalf of the American Farm Bureau, the National Mining Association, the American Petroleum Institute, and a range of others, including the Associated General Contractors of America, the National Association of Manufacturers, Cattlemen's Beef Association, and others. And this was a brief that was focused predominantly on the practicalities of the issue and the adequacy of alternative remedies. In addition to building on to the broad practical implications of denying immediate review, the brief touched additionally on other areas of the law where these sorts of questions come up, including in the mootness in the ripeness context, where the same sort of finality and adequacy issues arise, in the ex parte Young context, where the question is whether injunctive relief is available as a pre-enforcement measure. And in these other areas of law, we see exactly these same sorts of considerations. And the rule universally in these other areas of law is that regulated entities don't have to wait for the sword to drop in order to bring their challenges in federal court. Now, of course, these other doctrines arise under different legal regimes like Article 3 and so forth, but they represent a common and recurring theme across various areas of law that we think are going to be at the back of the justices' minds as they consider the case. West Virginia and 22 other states wrote a brief raising federalism concerns, which you see frequently raised in Clean Water Act cases, where, again, you know, the question of the extent of the agency's authority under the Clean Water Act begins to encroach on the prerogatives of the states to manage land uses within their own boundaries. The North Dakota brief, which was filed along with 5 other states, attempted to weave in a discussion of the new WOTUS rule and explain why, especially against the backdrop of the new and confusing WOTUS rule, it's especially important to have early review of jurisdictional determinations. There was additionally a brief by Council of State and Local Governments about impact on local governments, repeating some of the same themes as the West Virginia brief. The Chamber of Commerce, which is not listed here, also was one of the briefs that received a good deal of attention. It was a very helpful brief about more of the practicalities of the permitting process and how burdensome it is. And I think the point to take away from all of this is that, you know, tellingly, no environmental NGOs filed on behalf of the government in this case. And, you know, it's not altogether unsurprising to see that. I think environmental NGOs would be very happy to have an opportunity also to challenge negative jurisdictional determinations. And if the Hawks Company loses this case, they won't have that opportunity. And you know, more generally, environmental NGOs, I think, have an interest in holding agencies to account. You know, I think for different policy reasons, but ultimately with the same goal in mind, that agencies ought to be held to the text of the statutes that authorize them. And that in that context, more judicial review is better than less.
So what is at stake in the decision the court will render in this case should be pretty clear by now, but obviously the upshot for landowners, should the government prevail, we feel would be that they would be put between a rock and a hard place. They would be left with the unpalatable options we've talked about. If a landowner gets a negative, an adverse jurisdictional determination telling them there are waters of the United States on their property, they will have to choose between simply taking their chances with development and running the risk of being assessed penalties, which will almost never be an attractive option, or on the other hand, seeking a permit with all the costs and delays that entails. So they'll really be put in a difficult bind. And the other upshot we feel will be that the ongoing litigation over the WOTUS rule itself will come to take on even more importance, because obviously if landowners aren't to have the option to get early judicial review by getting judicial review of these jurisdictional determinations, it's even more important to try and get some clarity from the agency in a rulemaking as to the scope of waters of the United States. And that's what, among other things, that litigation is designed to address.
You know, and on that point, it bears mention that the Army Corps of Engineers issued an internal memo that was, I gather, I mean, maybe it was, maybe it wasn't, but was not at least ostensibly intended to be made public, that has since been made public, criticizing the new WOTUS rule And among the things that, that the Corps expressed concern about was that given the lack of clarity of the rule, that they will see more litigation challenging their jurisdictional determinations because you know, the less clear it is and the more arbitrary it seems that the Corps' decision-making is under the prevailing regulations, the more likely they are to see challenges. One issue that came up at argument, which we're going to begin discussing on the next slide, but I'll weave in here, is that it seems that the Corps and EPA have an interest in keeping jurisdictional determinations. One of the issues that came up in the briefing, of course, is that because jurisdictional determinations are not required by the Act and are provided by the Corps by regulation only, which the Corps presumably could erase from the Code of Federal Regulations, one upshot is that they could simply decline to give jurisdictional determinations if they have a concern that every time they do, they're going to find themselves in court. But at the same time, giving jurisdictional determinations is a very important regulatory tool for the Corps and for EPA. It gives them leverage early on in the regulatory process and allows them to compel, we would say, regulated entities into the permitting process, perhaps even where there is room for doubt about whether or not they should or can be doing that under the terms of the Clean Water Act. So the agencies themselves have an interest in continuing to give jurisdictional determinations because it allows them to continue to define and frankly expand their jurisdiction and to do it in a way that allows them to manipulate the behavior of regulated entities without necessarily having to go through the process of the full permitting and enforcement scheme. Now what that means, if Hawks wins, of course, is that landowners will get more clarity. You know, one of the other real practical concerns about a decision reversing the Eighth Circuit would be that if courts have fewer opportunities to pass on what waters of the United States means under the Act, it means the agency has greater leeway and is constrained less by judicial decisions, which the agency no doubt will think is a good thing, but regulated entities rightly will think is a bad thing. The less clarity there is, the more opacity there is, the more flexibility the agencies get, and the more arbitrarily they can act. And what that means, of course, is that the development of law will be slowed and regulated entities will have less predictability as this case itself demonstrates. So we'll share now a few thoughts on the oral argument which was held this morning before an 8-justice Supreme Court. It was a fairly active oral argument. There was a fair amount of questioning. You know, we've seen in recent terms that the court has become a bit more, I don't want to say respectful as though they weren't respectful before, but more respectful of advocates' time and allowing advocates to finish full thoughts and answers, which means that even in a case like this where the justices have a lot of questions, it is less hot of a bench, to use the vernacular, than we've seen in recent past terms. This is the developing theme on the Supreme Court, where there are fewer, it seems, interruptions of the justices of the advocates, by the justices of the advocates, and by the justices of other justices. So it was a fairly active panel, but even by modern standards, not as active as we've seen. I guess we saw a couple of different themes. At the outset, Malcolm Stewart, arguing for the government, began by leading off with the non-binding advisory nature of jurisdictional determinations And we saw the justices were fairly skeptical of that line of argument. Certainly, Malcolm Stewart acknowledged that if jurisdictional determinations are in fact binding, a point that he didn't concede, that there probably should be that there should be Administrative Procedure Act review under Section 704. The Chief Justice and Justice Alito, for their part, seem skeptical of the government's claim that jurisdictional determinations are not final and binding, at least with respect to the Corps of Engineers.
Yeah, and after that little skirmish, I would say that another major theme that developed in the government's argument was really the idea that practical consequences, again, are not enough to be a basis for liability. Malcolm Stewart, the government's attorney, was really analogized this case frequently to a Supreme Court case from the 1980s, Standard Oil, or perhaps it's a D.C. Circuit opinion. I can't recall, but that was a case where the court found that an agency order was not reviewable under the APA, even though it required a company essentially to appear and defend itself in an agency proceeding, because the time and expense of being in this proceeding were, a practical consequence, but there was no final legal consequence for the company, and so the government was trying really to analogize this permitting process that a jurisdictional determination might require of a company, to say that similarly, it's a practical consequence that the company might feel compelled to get a permit, but that as the government put it in its rebuttal, that our judicial system is more concerned about preventing piecemeal appeals than it is about saving companies the expense from going through proceedings like this. So that was a theme that he was repeatedly pressed on, and a line that he tried to draw.
One telling question on that score came from Justice Sotomayor, who asked if the government had ever declined to go after a landowner or land user after a jurisdictional determination had been made that there was water of the United States on the relevant land, and Mr. Stewart was unable to answer that the government had ever declined to enforce the jurisdictional determination, which certainly suggested, at least as a practical matter, that jurisdictional determinations really are final and that the government sticks to them once they have issued. That did not stop Mr. Stewart from insisting that jurisdictional determinations quote, have no legally binding effect on anyone, even the Corps of Engineers. Now, Justice Breyer, who was one of the more active questioners at the argument, seemed quite skeptical of the government's position. He returned, in particular, to the Abbott case concerning an agency rule about drug labeling. He noted that in that case, after the government agency action had become final, nothing happened immediately, and it wouldn't. The agency rule in that case wouldn't become an issue. Nothing would follow from it unless and until someone violated it, and then the government would have to make the separate sort of follow-on discretionary decision whether to prosecute. And he made what seemed like a fairly compelling case for why jurisdictional determinations are of the same ilk. Nothing happens immediately after jurisdictional determination issues. No one is told really to do something or not to do something. The status quo stays the same unless and until someone does something that is inconsistent with what the jurisdictional determination says or implicates is required under the Clean Water Act. And then again, there is this follow-on question then whether EPA or the Corps, or for that matter any other agency, or prosecutorial body makes the discretionary decision whether to prosecute and enforce. And so by Breyer's lights, it seems that the case was governed by Abbott Laboratories, and that this is precisely the sort of final agency action that you would expect to see reviewed under Section 704.
I would say the respondent's biggest critic was probably Justice Kagan, who analogized a jurisdictional determination from the court to a lot of other sorts of what she called informal agency guidance that agencies provide every day, whether it's a Treasury Department letter about a tax situation or an SEC advisory opinion saying that if the facts are as you've told them to us, we would not bring an enforcement action against you for this or that conduct. And her point, which the government had mentioned in its briefs, was that we want to encourage agencies to give guidance and to help inform regulated entities of their options and their obligations, and that making all these actions reviewable would deter agencies from doing that rather than encourage it. And I think the Respondents' Counsel, Reed Hopper of the Pacific Legal Foundation, I think tried to push back on that a bit by saying that this is that a jurisdictional determination is more formal and more binding than some of these other informal forms of agency guidance. I'm not sure Justice Kagan was convinced, but that I think is a distinction we would draw and one he tried to draw as well.
So just three final quick observations. The first is that it seemed to both Matt and me that Justices Kennedy and Ginsburg, that Justices Kagan and Ginsburg seemed, although sympathetic to the respondent's position, perhaps a bit more sympathetic to the government position. I think Justice Kagan expressed concern especially about how a ruling in favor of the respondent in this case would have spillover effects into the reviewability of a range of other sorts of opinion letters issued by other agencies, including, for instance, the SEC, and tax letters from the Treasury, all sorts of opinion letters that the government issues all the time. I think her concern was to ensure that that all doesn't sort of fall within the Section 704 ambit and really increase the amount of litigation that we see. That seemed to be her primary point of concern, and that Justice Ginsburg, I think, shared that concern. Interestingly, Justice Kagan raised the question whether if a jurisdictional determination really is a formal final agency action, whether it's entitled to Chevron deference. I think as soon as she suggested that, Mr. Hopper backed off quickly. On the other side, Justice Alito and the Chief Justice seemed quite persuaded that jurisdictional determinations are really tools that favor the government and that the government ought to be subject to immediate review. Justice Breyer also supported review on balance. Now, how it all plays out, of course, is anyone's guess. It's a 4-4 court. We may end up seeing a 4-4 decision, but a 6-2 or a 5-3 decision would not be a surprise. And one final note, Justice Kennedy, around the 10 or 15-minute mark, made a remarkable statement about the Clean Water Act itself, saying that its definition of waters of the United States was vague and, in his words, arguably unconstitutionally vague, which is a really remarkable statement, particularly from Justice Kennedy in the context of the Clean Water Act, and is certain to be a point that will be raised in the WOTUS litigation. Now that concludes our presentation. As I mentioned before, if you submitted any questions that we didn't answer, we'll be sure to follow up with you directly. And should you have any additional questions related to anything that we've discussed today, please email them to Annie Ledger at aledger @mayorbrown.com. and your questions will promptly be forwarded to Matt and me, and we'll be happy to answer them. Thank you again for your participation today, and have a great day.